There's an interesting case of sexual harassment or discrimination there, sexual harassment, in the media today. The WRC dealt with the case. It involved an office worker who suffered trauma, in inverted commas, when a colleague tried to pull down her trousers at work, in the workplace. She was awarded €50,000 against the courier company. The WRC adjudicator found that the woman was wholly credible in terms of her evidence and the trauma that she had suffered, and she was awarded the maximum allowed for the complaint, and the maximum allowed in this particular situation is 2 years' wages. So she was awarded 50 grand. The background is she suffered extreme distress and trauma when a male colleague came from behind and tried to pull down her trousers in front of other staff in the workplace. The WRC ordered the maximum sum it could to the worker, having found that her employers, Deadline Couriers, Deadline Direct Limited, trading as Deadline Couriers, failed in its duty to put harassment prevention measures in place before the sexual assault. It also found that its handling of the affair afterwards did not mitigate this in any way. The complainant was a lady called Charlotte O'Brien. She had been accused by the firm of failing to engage with its appointed investigator, the company accountant. However, the company accountant left a WRC hearing in February early before he could give evidence to back up that claim. The adjudication officer found that Miss O'Brien had done what was asked of her in the company investigation, and she gave an uncontradicted and wholly credible evidence before the WRC of being subjected to a sexual assault by her colleague. The adjudicator noted that he had watched the CCTV footage of the attack in 2021 and witnessed the male colleague, named only as Mr. X, both placing his hands on Miss O'Brien and making an attempt to pull her trousers down. Miss O'Brien at the time said she was leaning against the wall in an open plan office with her hands full with rolls of shrink wrap and sellotape when Mr. X carried out the assault. It was done in front of a room full of male colleagues while her hands were occupied, she said. She said Mr. X then proceeded to joke and mimic what he had just done to other female workers. None of the numerous male colleagues who witnessed this said anything or assisted her, said her barrister. Miss O'Brien said she left the room and reported the matter to a duty manager who didn't tell her to go home and didn't do anything, adding that when she went back to the office, Mr. X was still in his seat and had not been told to leave. She said Mr. X had been making comments on her appearance and weight for several months before this. The WRC heard that the company began an investigation in June 2021 with the company's accountant, Austin Bergen, formally interviewing her. Miss O'Brien took sick 7 days later, and the firm stopped her pay a week later, leaving her to use her annual leave entitlement and then take up a social welfare payment. She reported the matter to the Gardaí, was attending a counsellor and remained unfit to work. But despite this, the respondent continued to put pressure on her to return to work, her solicitor said. Mr. X resigned without being interviewed, and Miss O'Brien, the victim, was not given any investigation report. The investigator appointed by the firm, Mr. Bergen, left the hearing before he gave evidence, stating he did not think the matter would take so long, the tribunal noted. Solicitor for the company said none of its staff had ever made a complaint against Mr. X before, and that it was so unique, that the incident, that it could not have been reasonably foreseen. He submitted that the company's procedures were effective, but that Miss O'Brien did not fully engage with the grievance process and failed to invoke its grievance procedure, arguing that the firm was prevented from taking steps to address the matter in accordance with their legislative requirements because of her alleged refusal, according to him, to use its grievance process. The company's chief executive said in evidence that these had been provided to the complainant in the company handbook. However, the adjudicator wrote that there was no documentary evidence supporting that contention, which was disputed by the complainant, who said she did not receive the handbook. The adjudicator found that the employee handbook did not contain a clear and distinct policy on sexual harassment, and that had not been provided to the complainant, and that there was no evidence of training having been provided to employees before the date of the sexual assault, he wrote. There were no preventative measures whatsoever taken by the respondent, and he added that the alleged investigation by the accountant, Mr. Bergen, did not mitigate this in any way. Mr. Bergen is the respondent's accountant, and there was no evidence presented to suggest that he had any expertise in these. If he had, I believe he would have produced a report with findings, Mr. O'Neill, the adjudicator, wrote. I noted the extreme distress and trauma that she displayed when giving her direct evidence almost 2 years after the assault, as well as the apparent understandable breakdown of her trust in the respondent given their actions after she made her complaint. In particular, it is scarcely credible that she has still not received an outcome of the very serious complaint that she made. The adjudicator said that the complete investigation report could have reversed some of the effects of the investigator of the discriminatory statement treatment. He said that a new dignity at work policy since brought in by the company will be of little benefit to Miss O'Brien, and Mr. O'Neill noted that she was still an employee but unlikely to get back to work soon. He ordered the firm to pay the maximum compensation in the matter, 2 years' pay, to Miss O'Brien, a sum of €50,440. One of the biggest problems in this case for the employer was that they actually didn't deal with the issue well. They dealt with it in a manner that is likely to lead to an adjudicator at the WRC finding against you and finding against you big style. And this is big style when you're looking at the maximum being 2 years' wages. Problem is the respondent's account, or the no report, was produced with findings. And he also noted that it is scarcely credible that she has still not received an outcome of the very serious complaint that she made. So the basic fundamental for an employer dealing with a situation like this is to deal with it seriously, carry out a fair investigation, interview the respective parties, witnesses and so on, and come to a reasonable, rational conclusion, and ensure that everybody has an opportunity to give evidence if they wish to do so, and if they are of assistance to the investigation. But the key thing is the employer can mitigate the loss or the amount of money that's going to be awarded against them for the sexual harassment in the workplace if they take preventive steps to address the matter in accordance with their legislative requirements, and if they take it seriously. Hope you find this video useful. If you do, I'd appreciate if you give it a thumbs up down below. Thanks a lot.